Good afternoon, everyone. Welcome to the Joint Standing Committee on Judiciary. We will begin with committee introductions. Representative Sinclair.
I'm a little bit lonely here on this side, but I'm happy to start. Good afternoon. I'm David Sinclair. I'm here for the people of House District 50, which is the city of Bath.
You are alone over there. Good afternoon, everyone. I'm Elizabeth Caruso. I represent the people of House District 72, which is much of northern Somerset County.
Good afternoon. I'm Mark Babin. I represent House District 3, Northeast Somerset County.
Hello, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good afternoon. I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Good afternoon. I'm Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, and some of Scarborough. I serve as the Senate Chair. I will be absent for the first part of the committee meeting today.
And I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee. We have a series of 4 work sessions today. We're going to take things a little bit out of order and begin with LD 2207, an act regarding the statute of limitations for certain sexual offenses committed against minors. And before we get started, let's just give committee members a moment to introduce themselves.
Thank you, Madam Chair. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Good afternoon, everyone. I'm Dylan Hugh. I represent House District 114, which is part of Portland.
Janet's going to give us the bill analysis. Just waiting for everything to be distributed. All right, we're ready for you, Janet.
So LD 2207 is an act regarding the statute of limitations for certain sexual offenses committed against minors. So this was a committee bill, and it proposes to eliminate the statute of limitations for the prosecution of the crime of aggravated sex trafficking when it's committed against a victim who hadn't attained the age of 18 years at the time of the crime. And that statute was handed out on this very bright colored goldenrod at the public hearing. So if you want to look at that there. Also, it would eliminate the statute of limitations for prosecution of the crime of commercial sexual exploitation of a minor when it's committed against a victim who hadn't attained the age of 18 years at the time of the crime. These new limitations periods would apply only to criminal conduct occurring after the effective date of the legislation or for which the prosecution has not yet been barred by the statute of limitations in force immediately prior to the effective date of this legislation. There is a word or, a stray word or in the summary, which might lead you to believe otherwise. So just read this summary of when it applies. Or just read the application section directly of the statute or proposal, excuse me. So as background information, under Section 8 of the main criminal code, which was handed out at the public hearing, or you can just take out your handy criminal law books. A prosecution generally for a class A, B, or C crime, these are punishable by more than a year. So in the vernacular, we tend to refer to them as felonies. Those generally must commence within 6 years after the date that a crime was committed, while prosecution for a class D or E crime, which are punishable by less than a year, so they're commonly referred to as misdemeanors, they generally must commence within 3 years after the date that the offense is committed. But these limitations periods may be tolled or extended in certain circumstances that are set forth in the statute. including, just as an example, for a period of up to 5 years when the defendant is absent from the state of Maine. The Maine Criminal Code establishes lengthier limitations periods beyond these default 3 years for a misdemeanor, 6 years for a felony, for certain offenses, including certain sexual offenses committed against adult or minor victims. In 2019, for example, the legislature established that the prosecution of a Class A, B, or C crime involving unlawful sexual contact or gross sexual assault has to be commenced within 20 years after the date of the offense. However, if the victim had not attained 16 years of age at the time of the offense, in 2019, the law provided that a prosecution for incest, unlawful sexual contact, sexual abuse of a minor, rape, or gross sexual assault could be commenced at any time. So there wasn't a limitations period for those specific crimes if the victim was under 16 years of age. In 2023, or that legislature, the law was amended through what was LD 1790 and enacted an act removing the statute of limitations on civil actions and criminal prosecutions for certain sexual offenses against minors. So that legislation, it did affect some civil statutes of limitations that I'm not going to talk about, but it also expanded the list of sexual offenses against minors for which there is no limitations period to include all of the previously listed crimes, although previously those had to be committed against someone under 16. So it raised that to under 18. And then it added the crimes of unlawful sexual touching and sexual exploitation of a minor. And then last year, through what was LD 1427, an act extending the statute of limitations on criminal actions involving aggravated sex trafficking that went through this committee, you further provided that a prosecution for a Class A or B crime of aggravated sex trafficking has to be commenced within 20 years after it's committed. And that bill did not distinguish about the age of the victim. So that was just a 20-year provision. But as part of this law, you directed the Criminal Law Advisory Commission to examine all of these statutes of limitations provisions about sexual offenses, including by whether determining that parity exists between the statutes of limitation and whether the extended limitations period established in the Maine Criminal Code should apply to any other sexual offenses in the state. So that's how we got to where we are today. So in its January report, the Criminal Law Advisory Commission made several recommendations. Only a few of them are in the bill, and I'll explain why in a second. So the first recommendation that they made, well, they noted that the crime of aggravated sex trafficking, that's the one that was amended through 1427 last year, was recently placed in the 20-year limitations category, and it includes both Class B crimes committed against adults and minors and Class A crimes committed against minors under the age of 14 or other offenses that are elevated due to priors or things like that. And per CLAC in its report, to be consistent with its approach to other sex crimes against children, the legislature may consider placing aggravated sex trafficking against a minor within the no limitations period provision of statute. They made that similar recommendation regarding commercial sexual exploitation of a minor, noting that it's also a sexual offense against a minor. It's not in the 20-year category and it's not in the no limitations category, which means that it's currently subject to the 6-year period limitations period. And they thought that was not in parity, which is what you asked them to point out. They also, in a third recommendation, strongly recommended that any future changes to statutes of limitation include guidance and specific effective dates in the language of the enacted statute. That's not how this bill is drafted, but we can absolutely amend it to do it that way. It just depends on, you have to pick a date. And then the last thing that they noted, although they did not make a specific recommendation on the issue, the Criminal Law Advisory Commission observed that some of the policy reasons for eliminating the statute of limitations for young victims, including delayed disclosure, seriousness of the offense, and vulnerability of the victim, could also apply to a victim who suffers from a mental disability. And so for that reason, the legislature, it noted, may wish to consider whether the crime of commercial sexual exploitation of a person with a mental disability should also be subject to an extended limitations period, either 20 years or no limitations period. They didn't recommend either one. Since that was just an observation, it didn't include a specific recommendation. That provision of the report was not included in the bill. So the bill focused just on recommendations 1 and 2, the sexual offenses against minors. It didn't, like I said, implement recommendation 3 because I did not know what date you would want to pick and I didn't want to guess. And you can easily amend it and put the date right in statute if you want to do that. So that's where we are with the bill before you. Just so that you see exactly how this works in current law, if you're going through Section 8 of the Criminal Code, murder, regardless of the age of the victim, has no limitations period. Certain sexual offenses against minors, which I've already listed, including incest, unlawful sexual contact, sexual abuse of a minor, gross sexual assault, unlawful sexual touching, and sexual exploitation of a minor. All of those also have no limitations period under current law. Based on last year's bill, Class A and B aggravated sex trafficking, whether it's against a minor or an adult, so the next 2 rows of the chart, are subject to a 20-year limitations period. What this bill does is say if the victim is a minor, it would be no limitations period. So that's one of the changes of the bill. The next category are Class A, B, and C unlawful sexual contact and gross sexual assault. If the victim is an adult, it's the 20-year limitations period. Both of those crimes are in the list above for the no limitations period for minors. There is also commercial sexual exploitation of either a minor or a person with a mental disability. Both are currently a 6-year statute of limitations, and the bill proposes, if the victim is a minor, to eliminate the limitations period. And then the last 2 parts of the chart are just the defaults. If nothing else is specified, those are the default limitations period. So as far as issues that were raised or proposed amendments you may want to consider, you may want to wish to amend the bill to provide a specific effective date. I suggested perhaps September 1st, 2026, because hopefully that's 90 days after you adjourn. That's really not up to me. That's up to you all. Or another date that you are sure is more than 90 days after adjournment, unless you want to add emergency preamble. And you could set forth that date in statute as recommended by the Criminal Law Advisory Commission. A second issue that was raised, again, based on one of the observations in the CLAC report, was whether the committee wishes to amend the bill to extend the limitations period, choosing either the 20-year period or no limitations period for the crime of commercial sexual exploitation of a person with a mental disability. That was suggested in the CLAC report. We have testimony from the Maine Coalition Against Sexual Assault, and now attached to this bill analysis from the Maine Prosecutors Association supporting that type of change. I thought it would be helpful, so I just did a word search and looked through all the sexual offense crimes to look at anything that involved a person with a mental disability to see if we're catching everything. So the chart below is, if we look, I just want to back up for a second, look at all of the offenses, sexual offenses against a minor that don't have a limitations period. Those are the types of offenses that the legislature has made the decision that these are serious enough and we want to not have a limitations period for when the victim is a minor. If you believe that the policy reasons for that choice are similar for adults with a mental disability, the question is, are all of those similar offenses in the no limitations category for adults, or at least the 20-year extended period? So if you look at the gross sexual assault, Class B and Class C offenses that are committed against folks who are identified in the elements of those crimes as having some type of mental disability, those are already in the 20-year extended limitations period category. If we go to the next page, or the top of page 4, unlawful sexual contact, when that is a Class C crime. So these are unlawful sexual contact crimes involving penetration, and the victim has a mental disability of some sort. Those are all already subject to the 20-year statute of limitations because they are Class C, and that's the way that is written in statute. However, if it's unlawful sexual contact not involving penetration with the same types of victims, it's a Class D crime. It's not elevated, so it goes to the default, which is 3 years for a misdemeanor. So that's the limitations period currently. Similarly, for unlawful sexual touching, although all of those offenses against minors have no limitations period, the ones that I found in statute involving specifically victims with a mental disability are Class D, so they're subject to the default 3-year period. And then aggravated sex trafficking and commercial sexual exploitation are the two that are the subject of this bill to make those, when the victim is a minor, have no limitations period. If you look at those crimes being committed against a person with a mental disability, aggravated sex trafficking is a Class B, so that's subject to the 20-year limitations period. That's the change you made last year. And then commercial sexual exploitation of a person with a mental disability is Class C, and that is currently subject to the 6-year limitations period.
Let's just pause for a moment if
Yeah.
we can and see if there
Sorry,
are
that's
questions.
confusing.
I'll just start with a question. I'm surmising from the way this is laid out, there is not a definition in statute of person with mental disability. It's varying depending on.
Yeah,
the
so I
charge.
tried to summarize the way the statute referred to each. So most of the time, it's written as a mental disability that is, it's actually reasonably apparent, but I had already made the chart long enough. Reasonably apparent or known to the defendant, so that's part of the element of the crime. And it has to render them incapable of understanding what's going on or that they can deny consent, either of those things. So that's most of the descriptions. There's at least one other place where it refers to someone who is receiving services for autism or intellectual disability. I forget which one that's in. But it's really the language that I've summarized here.
Yeah.
And I gave you the actual sites, so if you want to look up the statutes, we have them all in front of us.
Thank you. Are there other questions, committee members? Representative Lee?
Looking in your chart on the unlawful sexual contact and unlawful sexual touching Class Ds, when it comes to minors, is that also 3 years for them? I think your chart says yes, but I'm just wondering.
No, if you look, so this is just a list of crimes against persons with mental disabilities. If we look at the current law chart, which starts on the bottom of page 2,
Mhm.
there's a whole list of sexual offenses. They range from Class E all the way up to Class A. And if they're committed against minors, and that includes unlawful sexual touching and unlawful sexual contact, those are all, regardless of the class, no limitations period.
Mm.
And I will say, this chart, I know it's long and crazy because Janet wrote it, but it's actually summarizing a lot because all of these offenses can be elevated if there's a dangerous weapon or if it's a repeat offense. So there are ways that you might bump up an unlawful sexual contact to a Class C, and then it would have a different limitations period. But this is just the general default first offense, no dangerous weapon, statute of limitations.
Representative Crusoe?
Thank you so much, Janet. It's really easy to kind of categorize things and see not just the category of crime, but how we deal with minors, help minors differently than adults. If we were to add, I mean, in my mind, just speaking to the committee, it seems indicative, and I know that Clack recommended us, we could look at it, that someone who does have a mental disability could in many ways be at the same kind of level of a minor in terms of being able to defend themselves or communicate or whatever. And so if we were to incorporate a victim with mental disability into this and treat them in the same way that we would a minor, is that it would have to be obviously added into these different statutes, as well as where Is there a special category that's just for people with mental disability, or is it just added into these?
So there's each of these offenses has many, many different ways they can be proven. So different elements. So it could be, I just want to back up and say, it could be that in fact, a victim has a mental disability and they're not charged under one of these provisions because maybe they don't want to bring that evidence in, or for whatever reason, there's a plea deal or something like that. But what we're talking about is just when the element of the crime of a person with a mental disability is proven. That wasn't your question, but I did want to be clear about that.
Okay.
Okay, so I think what is true now is there's this rubric of certain, all but maybe these two that are left in the bill, sexual offenses against minors, and maybe some other very minor things like the dissemination of child porn rather than creating it. But all of those are no limitations period if the victim is a minor. And the two most serious of those offenses, gross sexual assault and unlawful sexual contact, if the victim is an adult, are 20 years. And then everything else is the 6 years or 3 years, depending on whether it's what we think of as a felony or misdemeanor. I think one approach you could take is to say, well, the only other felony level crime defined as committed against a person with a mental disability, which is commercial sexual exploitation, the last one. That's the only one that's not at least 20 years. So you could say, well, we'll move that one up to 20 years. And I think that was one possibility. It was kind of the most directly discussed in the CLAC report. But as you pointed out, if the policy decision really is that the reason for having an extended period, if the adult has a mental disability, is the same type of reason as for a minor, you could consider moving all of these into the no limitations period category. That's one option. Or you could say, we're at least going to move them all into the 20-year limitations period category, as with the other more serious crimes against any adult. Okay. So I think those are like, there's a range of options. Or you could say, we want to think about that more and just move ahead with this now and direct somebody to think about it more, or just yourselves think about it more.
Thank you for laying out those options. It's helpful. Are there other questions? Okay, let's keep going.
Okay, and then I just, I know that last time when we talked about LD 1427, there were questions about the ex post facto clause. I'm not going to go over it, but I put in the same explanation and I have the cases copied if anyone wants to see them. I mean for myself, but we can run copies of how the US Supreme Court has said, as long as, well, actually what the US Supreme Court said is, if you have a statute of limitation, say 6 years, and 7 years have passed, and then the legislature says, we want to make it 20, it's too late. You have told that defendant that they are not subject to prosecution anymore, and the policy reasons for that not being okay on the under the ex post facto clause are the defendant is no longer trying to preserve evidence as far as they know, so any type of protection they might have, they have no reason to think that they need to keep moving forward with that. However, the Supreme Court in that case specifically said we are not invalidating any laws that extend the statute of limitations before it's expired. So if it's a 2-year statute of limitations, I engaged in conduct last year and the legislature changes it to 5 years, it hasn't expired yet. So any, all of my defensive instincts of preserving evidence and everything, they're still going because it hasn't expired yet. This is just a simple policy explanation. So the US Supreme Court said, we're not invalidating those. It wasn't the case before them. And they mentioned, we're not invalidating those. And the law court has since said, we agree with that as our interpretation of the constitutional provisions. That type of change doesn't violate the ex post facto clause. That's why all of these applications say it's either new criminal conduct, that's pretty clear, or as long as the limitations period hasn't already expired. So I just wanted to remind you of that distinction. You don't have to follow that distinction. You could just say new criminal conduct. It's entirely up to you. I don't want to pretend you're bound by that, but that's why these are written that way. because that's the decision the legislature's made in the past and it's been upheld by the law court. When we had the hearing on this committee bill, there was some discussion of maybe going straight to work session, and I spoke to lots of different legislators, and some asked if there was any data on really what impact would this have. So questions were sent to the main judicial branch just about conviction rates for these specific crimes that are being considered for extended statutes of limitations, and then also to the Maine Prosecutors Association about whether they're aware of any instances where the current statute of limitations for these three crimes that are mostly being considered in this bill, whether that current limitations period has prevented bringing a prosecution against someone. And so we have their answers attached. In addition, the MPA representative wasn't able to submit testimony before the hearing, but she did submit testimony, which I just attached since she sent it in the same email. And I did want to point out that we don't have the fiscal information yet, but you did pass that law last time that extended the statute of limitations. When you do that, there will be a fiscal note, most likely, that is similar to this one, which just indicates that it's not possible to quantify, but there might be an increased number of cases, which could lead to more people being incarcerated. And so that is sort of a potential cost increase. It's not my understanding that would go to the table, but that's really not my decision.
Okay, other questions for Janet? Committee members have questions for anyone else? We have this new testimony from Shira Burns. Yes, Representative Lee.
Mine's for Clack.
Thank you. Can you join us, please? Welcome.
Thank you. Good afternoon. My name's Laura Ustak. I'm here on behalf of the Criminal Law Advisory Commission.
Thank you. Do you have Janet's chart?
Yes.
You all surfaced for us sort of the issue with section 855 sub 3, the folks with mental disabilities, moving that from 6 to 20 in order to provide some consistency. Janet has sort of also isolated two class Ds here, unlawful sexual contact and unlawful sexual touching, which both have sort of the separate categorization and statute of limitations for people with mental disabilities. And I'm wondering whether Clack looked at those as potentially increasing as well, and if you did, what was the conversation like?
We did not go down that path because we recognized that that was a very significant policy issue for the committee and the legislature to address, whether or not they wanted to treat victims who fell into that particular category the same way for the purposes of the statute of limitations, because it's a very policy laden area. And it wasn't specifically assigned to us in the report request. But we felt compelled to bring it to your attention because we noticed that kind of dichotomy.
Follow up?
There we go. So you brought to our attention the class C, and I guess my question is, you brought to us the class C, did you not think it was desirable to go further to the class Ds, or should I just not read anything into the decision not to look at those?
Well, in addition to it being such a complicated policy issue, one of the things we also mentioned in passing in the report is that any assignment of a limitations period logically should be linked not just to who the victim is, but also the level of seriousness that's already assigned to the crime by virtue of the class. So when you look at the criminal code, the legislature has already said, okay, certain crimes are super serious. Those are class A's. And then goes down, it's kind of down the hierarchy there from most to least serious being class E's. So because some of those crimes are only Ds or Es, there is an argument to be made that if you take that into consideration with the nature of the victim and the nature of the crime, maybe you don't want to extend that statute of limitations period. Obviously, the legislature did not do that with respect to crimes against children. The legislature said regardless of whether it's an A or an E, if the crime is against a child, if it's this type of crime against a child, there's not going to be a statute of limitations. So I think you have to ask yourselves the same question. If it's this type of crime against a person with a mental disability that renders them unable to appreciate the fact that they can consent or not, do you want to treat those crimes the same way for the purposes of the statute of limitations? And we didn't go there because we felt that was your decision to make. But it, factored into that is not just the nature of the crime, but is it A, B, C, D, or E? And, at the very beginning, you look at the criminal code and most crimes are assigned to categories based on that level of seriousness that's been previously determined. Does that,
Yeah.
did that make sense?
Yeah, no, I think you answered my question. I was just curious why you guys didn't go into it. I understand that there's a policy question that we have to ask ourselves. I'm very much asking myself that policy question with respect to the two D crimes that we have here.
Yeah, we realized we were opening the door to a much larger discussion and didn't want to go too far down that path.
Doors open now. Thank you.
I would add also that even the one that's going to 20, the Class C crime wasn't a recommendation of CLAC. It was an issue that you surfaced, which is a little bit of a different category than the changes that are actually proposed in the bill. Are there other questions for Laura Ustak? All right, thank you very much for joining us.
You're welcome. I'll stick around for your.
We appreciate
discussion.
that very much. Would anyone like to hear from anyone else in the room? Or would committee members like to engage in discussion, take a break and caucus for a few minutes? Yeah. Okay, so it looks like we're going to break for a caucus. Is there any other information anyone needs at this time? Don't see any. All right, let's try to be back in about 5 minutes. All right, committee members. Welcome back to our work session on LD 22,207. Are there any questions? Senator Hagan, would you like to introduce yourself?
Hi there, I'm Dave Hagan, Senate District 10, several towns surrounding Bangor, not Bangor.
We're just going to pause a moment for the video. Thank you, Janet. All right, thank you. Committee members, are there any questions at this time? Any committee discussion? Representative Lee?
Just to get that committee discussion going, I'd move ought to pass.
Thank you. And is there a second? Representative Caruso? Is there any committee discussion? Janet?
Not committee discussion, just clarification question. Are you purposefully, which is totally fine, not putting a date in?
You had the suggestion of September 1st, 2026. I would move ought to pass as amended with that as the implementation date.
Okay.
Thank you for that clarification. Any committee discussion? Representative Lee?
I think I'd just say that the real intent of this bill is to bring some uniformity to the way that we deal with sex crimes dealing with minors. I thank CLAC, and I think everybody surfaced some interesting issues as to how we deal with crimes with folks with mental disabilities. I just don't think I have enough information to make a policy decision based on that right now. And I don't want to make an ad hoc policy decision on one crime and lead us to that same disuniformity we've had in the world of children. So that's why I've decided not to have any other additional amendments to this.
Yeah, and I support that approach as well. Representative Caruso?
I agree. I'm glad we're bringing minors into the unlimited timeframe, and I'm really interested in looking at the individuals with mental disability the next session, but I feel like it was a kind of unclear what is defined and what is included in mental disability, and we just need to also hear from the organizations that minister to their needs to really understand that situation better, but I think it's definitely worthy of our time next time.
Thank you. Any other committee discussion? Okay, not seeing any. I think we're ready for a vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
No.
Senator Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Sinclair.
No.
Representative Sinclair votes no. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson. Representative O'Halloran. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Representative Henderson. Representative Henderson is absent. Representative O'Halloran. Representative O'Halloran is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 7 members voting in the affirmative, 3 members voting in the negative, 4 members are absent, and that is the vote of the committee.
All right, thank you. And for the folks who voted in opposition, what is your report? Can you put it on the mic, please?
Mine is ought not to pass.
Okay, same. All right, thank you. We'll close the work session on 2207.
We are going to move on to our next work session, and we're going to open up a work session on 2 pieces of legislation which are related to each other, and we have some proposed amendments that might or might not combine the 2. And that is LD 2193 and LD 2195. So we're opening up a work session on both of those. 2193 is an act to extend the requirements that the Maine Commission on Public Defense Services compensate certain private attorneys appointed to provide indigent legal services. And 2195 is an act to prohibit the appointment or assignment of a private attorney to provide indigent legal services without that attorney's consent.
Great minds think alike. I put them in the same bill analysis. That was handy. So just to remind you how we got to where we are today. Last year, the legislature enacted what was known as LD 1101, became Public Law 2025, Chapter 40. And it imposed a duty on the Maine Commission on Public Defense Services to reimburse private attorneys appointed by the District Court, Superior Court, or Supreme Judicial Court, either to fully represent a person or to provide limited represented to a person who's entitled to indigent legal services in a pending case. So under that law, which was codified in Section 1807-A of Title IV, sorry, it's just 1807-A is this version. PDS was responsible for compensating these court-appointed attorneys only if the court first found the following. First, that no public defender, assigned counsel, contract counsel, or employed counsel was available to represent that person entitled to indigent legal services. And I gave you a brief snippet of what each of those terms means. In addition, the court had to find that the attorney was willing to undertake the representation, that the attorney had not previously been disqualified by the Commission on Public Defense Services, and that the attorney to be appointed was, in the court's opinion, qualified to serve as counsel in the matter, and by statute related to that qualification, if the appointment was made in district or superior court, the attorney had to have at least 3 years of relevant legal experience. And if the appointment was for an appeal in the Supreme Judicial Court, the attorney either had to have those 3 years of relevant legal experience or have had experience as a law clerk analyzing relevant cases. The law also specified that if PDS was required to compensate a private attorney under that law, the amount of compensation and reimbursement, quote, must be equivalent to compensation and reimbursement provided to assigned counsel, end quote, under the rules that are adopted under Section 1804-2F. And these rules direct PDS to adopt rules establishing standards for the reimbursement of expenses incurred by assigned counsel, contract counsel, employed counsel, and public defenders, including attendance at PDS training events. And then also, the law directed that the process for compensation and reimbursement, quote, must be in accordance with the requirements established by PDS under subsection 3B of 1804, which directs PDS to develop and maintain an assigned counsel voucher review and payment authorization system that includes disposition information. I quoted those to you, not just to be annoying, but because questions came up about auditing, and those provisions aren't specifically about auditing, which I think is helpful in understanding why that testimony happened at the public hearing. In addition, the law specified that PDS supervision of the attorney was limited to fielding complaints by the indigent legal services client, so not other complaints about them or maybe this auditing type of complaint. That bill included a sunset clause, and so that law was automatically repealed earlier this month on February 1st. So in sections 4 and 5 of LD 1101, as it was eventually enacted, you directed PDS and the main judicial branch to submit reports, which they did in January, including information on how that law was implemented and providing recommendations for either improving or repealing the law. And the two bills that you're now working, LD 2193 and 2195, are proposed to implement the competing recommendations, at least at the time the bills were printed, of the branch and PDS. So LD 2193 would be emergency legislation, which would essentially reenact LD 1101. It's already gone because February 1st has passed, so it has to reenact it in a new location. And so it would, again, require PDS to compensate private attorneys if all of the requirements from 1101 last year are met. And that new statute, as the bill is printed, would be automatically repealed a year from the last time it was repealed, so next February 1st. By contrast, LD 2195 implements the Public Defense Services recommendation, so it wouldn't reenact LD 1101, and instead it would prohibit a court from appointing or assigning a private attorney to represent a person eligible for indigent legal services unless two things were met: the private attorney consents to the appointment and PDS determines that the attorney is eligible for the appointment. So I gave you some background on the policy arguments, mostly because they explain why the different approaches are taken. I'm not going to go through that. You probably remember that from the hearing. I did note in there some information also from the Maine State Bar Association on how it interpreted the need for either of these pieces of legislation. But as far as proposed amendments, which we have 3 different lovely colored amendments before you today, I want to summarize those for you. So remember, LD 2193 is the version that implements the judicial branch recommendation of reestablish that 1101 provision and extend it for a year. That's how the bill was printed. With respect to that, the Maine State Bar Association proposed clarifying that a court may not appoint or assign a private attorney unless the private attorney consents in advance of the formal appointment. So not just that they're willing as the current law is written, or that they consent as the other bill is written, but that they consent in advance. And then the Maine Judicial Branch submitted this yellow proposed amendment to LD 2193. And remember, this was originally their bill, but they have some refinements. And so they wanted to, if you look at that proposal on the bottom of page 1 or the front page of the amendment, they would add a definition of private attorney to the definition section of the statutes that govern the Maine Commission on Public Defense Services. And so that private attorney would mean an attorney who's not a public defender, contract counsel, or employed counsel. And then on the back, if you turn it over, it's hard to see the shading, so I'm going to point out for you the amendments to sort of the meat of the bill. In paragraph C of subsection 1, instead of saying that the attorney is willing to undertake the representation, they proposed that the attorney consents to the appointment or assignment. The same change would be made in subsection 2C involving appointments by the Supreme Judicial Court. And then they actually proposed changing the sunset date to April 1st, 2027, which is approximately 1 month from now, which may seem a little bit startling, but remember, this is emergency legislation, so it's not like it would be repealed before it got enacted, if that makes sense. Oh, okay. I thought it was a month. Okay, a year and a month. Thank you. Yeah. That makes so much more sense to me. Thank you. I was obviously tired. Thank you for clarifying. Okay, so that's the original proposal from PDS. The Maine Judicial Branch. Then in Salmon, the Maine Commission on Public Defense Services looked at what the judicial branch proposed, and they did talk about that they were going to look at each other's proposals. And they suggested some refinements to that proposal. So if you look at the definition of private attorney, that would be added to the Public Defense Services statutes. It would say an attorney who's not a public defender, contract counsel, employee counsel, or assigned counsel. So the clarity is these are attorneys who aren't on the roster, who aren't regularly going to be appointed to these cases through the typical PDS system. That's what private attorney would mean. And then if you turn on the back, they were fine with the language that had been proposed by the judicial branch for subsection 1, paragraph C, subsection 2, paragraph C, at least as of last night. I have an update to that. But in the compensation provision, they wanted to add language clarifying that PDS would not be responsible for compensation unless the attorney was lawfully appointed by the court under these subsections, and to provide that the commission could decline to reimburse or compensate an attorney for expenses to the same or tasks performed to the same degree they can decline compensation or reimbursement for folks who are assigned counsel. So the same type of rubric of limitations of the work that will be compensated. And then also to add language stating that they only would be required to compensate one attorney appointed per client per docket number. So if the court for some reason wanted to appoint 3, they would only have to pay 1. I'm not saying that's a ridiculous proposition. That's just how I understand it. Now, since that time, it is my understanding, and the folks behind me can confirm, that there is agreement that in subsection 1C and 2C, which are about the attorney consenting to the appointment, that they're okay with adding the in advance language that the Bar Association proposed. And I'm going to look for a nod from the executive director, and she's agreeing. So I just want us to amend this salmon amendment because they're fine with that. So it would say consent in advance, and all of this will be wordsmithed later. So those are all of the proposals that you have in front of you. Yep, for 2193.
So does the judicial branch agree with the added, statements about reimbursement?
I have not spoken to the judicial branch, so I would suggest asking them directly.
Okay.
They
I
are
was
here.
just curious.
So first, committee members, any questions for Janet? Yes, Representative Sato?
Thank you, Madam Chair. I just have a clarifying question. Because on the salmon sheet, section 4, sub 3 compensation, my understanding of the language that has been provided is that they're putting a private attorney at this, so may decline to reimburse or compensate a private attorney at the same degree as assigned counsel. They're putting them in parity. But then in the definitions, on the same page, on page 1 at the bottom, number 6, private attorney, they're adding assigned counsel to the definition of private attorney. So why is there a distinction that has to be made if assigned counsel is already in the definition of private attorney?
So this actually, it's a negative definition. So those are folks who are not private attorneys. That is very confusing. Yes.
Any other questions for Janet? I have a language question for you, Janet. Which is, I'm looking at the salmon sheet, paragraph 3, sub A, the insertion of the word lawfully appointed by the court under subsection 1 or 2. And I guess my question is, regardless of whether the word lawfully is in there, would consent in advance be required? Because if there wasn't consent in advance, it wouldn't be appointed under subsection 1 or 2.
Well, first of all, I understand the idea of adding the word lawfully, but I believe that is already required, even if you don't add the word. I don't know if that was your question.
That is, yeah.
Yeah, I don't think you need it, but if that adds clarity to folks that maybe that wasn't something that was necessarily happening before, I don't see a problem with it, but I think it's required anyway. So the obligation of PDS to compensate is only if they've been appointed under subsection 1 and 2 as they are written.
Okay. Thank you. Any other questions for Janet? Committee members, do we wish to hear from a representative from the judicial branch?
Yes.
Yes, okay. Julie Finn, could you please join us?
Good afternoon, Julie Finn for the Maine Judicial Branch. And just to clarify a little bit, the draft that we provided yesterday at some point, which is the yellow draft, I guess. That was our attempt to basically combine LD 2195 and the provisions therein. Those weren't necessarily like our amendments per se, including the extension or the sunset date. You know, we would prefer that the sunset date be February 1st, 2028, but given conversations that we've had sort of in the hallway, April 1st of 2027 seems like a good compromise and one that is acceptable to everyone. So I think we can make this very easy for you in that, I think as Janet already stated, the judicial branch is fine with the amendments that PDS made, which was sort of after the yellow copy got, some of this happened after printing, so to speak, so it wasn't quite caught up. So we're fine with the adding of the words in advance in the two places that were mentioned. We're fine with the changes suggested by PDS in subsection 3 about the language that's there that is highlighted and bolded and italicized. Thank you, Janet. The triple. So that I don't need to read that. We're okay with that. And so I think that includes the changes that have been suggested by both the director of PDS and the Bar Association, who are all here today. And so that I think would resolve 2193, and then I believe 2195 could be ONTP'd, for lack of a better word. So hopefully that makes your job easier.
So I see that there are questions for you. Representative Sinclair, why don't you begin, please?
Thank you, Madam Chair. Good afternoon, Julie.
Hi.
I want to ask a question that's the answer to which is probably obvious to all other than to me. I'm looking at the compensation section in section 4(3), and particularly at the last sentence of that first paragraph in subsection 3A, the one which is bolded and underlined and italicized.
And highlight.
And highlighted. Given that the commission may decline to reimburse in the same way as they may decline to pay or reimburse for some appointed counsel, is it anticipated that the court would then pay for any of those expenses or services that the commission declined to reimburse and or compensate for, or just that the private attorney, so-called, would eat the cost?
My understanding on behalf of the judicial branch is that the court would not pay the difference, that what is not allowed by the commission would not be paid.
There are questions for Julie Finn? Can you, did you have one, Representative Caruso? Go ahead.
Thank you. Thanks, Julie. So the statement, and I'm just not familiar, but I just would like to understand, in 3B, the maximum of one private attorney per client per docket number. That's, sometimes we have heard that clients go through attorneys for different reasons, maybe when they're I'm thinking about an example of when they're incarcerated and they go through attorneys. So this is saying that only one, they could only go through one private attorney, but they could still get different public defenders, separate from this, outside of this, right?
So this probably is more of a question for Director Tarpinian, as I did not draft that language.
Okay.
So I interpreted it to mean if this case like goes to an attorney at a law firm, they can't have like 5 attorneys work on it and all bill for it.
Oh,
But I may be wrong about that. That was how I read that.
okay, thank you.
Could you please share your reflections on why you feel that 2195 is no longer needed? Because to me, it seems like with the inclusion of the definition of a private attorney, that maybe 2195 isn't completely covered by the language in the proposed amended version of 2193.
Well, you know, the judicial branch had strong objection to part of the language of that bill involving the court not having the authority to assign. I'm not sure what part is not included in 2193. I was under the impression that it was included.
It seemed to me like the consent provisions in the 2193 only applied to private attorneys. Janet?
The
Thank
other
you.
difference in the two that I see, and there may be more, is 2195 is saying you have to meet the PDS eligibility requirements to take the case, as opposed to whether you have the 3 years of relevant experience or law clerk experience. There may be other differences, but that seems to be a big difference between the two.
Okay, thank you. Never mind. Strike my question. Actually, no, I think the question is still
I don't know
relevant.
if this is helpful too, to say when we had these 2 reports from the judicial branch and from PDS, we talked about, did you want to report out one bill, including both separate bills? And my advice to you, and it remains, is if you want to combine these, you need to have the 2195 provision take effect when the 2193 one expires, because it's setting up a different rubric for how you appoint attorneys. For example, that qualification piece.
Okay, thank you. Other questions for Julie Finn? Committee members like to hear from Director Tarpinian? Thank you. Did you have others?
You're
Thoughts
all
you wanted
set
to
with
share?
me?
Okay, yes, we are all set with you. Thank you.
Good afternoon.
Welcome. Could you just introduce yourself and then we'll see if there are committee questions.
My name is Frela Tarpinian and I'm the Executive Director of the Maine Commission on Public Defense Services.
Thank you. Questions for Frela Tarpinian? Yes, Representative Lee.
So I'm just trying to understand your perspective, because building on the last thing that we were just talking about, I thought 2195 was there to sort of say the process that we implemented as an emergency last year is over, it's sunset. Now this is how we're going to deal with appointments. And so we have purple, we have salmon, and we have yellow. It seems to me if we did purple, you wouldn't need salmon or yellow, or you couldn't have salmon or yellow. I'm looking at salmon. Is salmon your choice if we don't do purple, or are you saying forget about purple, we want salmon?
Do you want me to go over the purple one first? Because we haven't gotten there.
That would be very helpful, Janet.
So
Thank you for that suggestion.
So in our rainbow of colors, yellow and salmon are modifications to LD 2193, which is the version of the bill that says, let's extend what happened last year in LD 1101. Purple is a proposed amendment to LD 2195, which is originally the PDS recommendation, and this is their refinement of it. So first of all, it's important to note that at the beginning of this session, LD 1796, which is attached, was allowed to become law without the governor's signature. It hasn't yet taken effect. But what that bill does is it repeals and replaces on the bottom of page 1 and top of page 2, a provision in the PDS statutes, which is section 1802-A. And 90 days after the legislature adjourns, that provision will say both that an attorney can serve both as employed counsel and public defender within the PDS office, and more relevantly here, that a court would not be able to directly assign or appoint a public defender or employed counsel to represent a party entitled to indigent legal services. Since that is a similar topic, PDS recommended moving the substance of this bill into that same statute. They're very related. So that's sort of the biggest change here. But then if you look at the language that they've now proposed to be added in subsection 3, it's going to say a court may not appoint or assign the counsel to represent a person who's eligible to receive indigent legal services unless they consent and the commission has determined that they're eligible. So I very purposefully skipped over the word assigned there because that is a big change. I want to point that out separately. So what they're trying to do is clarify here, at least as I understand it, that this statute is saying the court can't appoint somebody on a PDS roster unless they consent and the commission has determined that they're eligible. They would have to be eligible to be on the PDS roster, and the PDS roster folks, as I understand it, are assigned to counsel, at least under the definition, which you can actually see hopefully in the other rainbow amendments. Assigned counsel means a private attorney designated by the commission to provide indigent legal services at public expense. They're not going to designate someone they find unqualified. So I think that's how that works. So that, I think, is the clarification. So if you wanted to do these, I know I'm kind of going beyond just explaining the amendment, but if you wanted to do these together, gonna need a little massaging because if this is, well, maybe we don't need a massaging anymore. We would have needed massaging because originally the way the bill was written, it's a private attorney and that might not be assigned counsel. So then there might be a conflict between the two, but I think now you actually probably can put them together. Do you disagree? I'm thinking on the fly.
I don't think they can go together.
Okay.
I think they're mutually
Just worried.
exclusive.
So the extending of LD 1101 is saying if you're an attorney who's not on any PDS roster or working for PDS or contracted with PDS, then you're only going to be reimbursed in certain circumstances. The purple amendment to 2195 is saying if you're on the roster, you have to agree in advance.
Yeah.
So I don't actually think those are in conflict anymore. If through the Salmon Amendment, this whole process only applies to people who are not on the roster. Does that make sense?
Yeah.
Okay. I just wanted to check that we're all on the same page because things have changed. So whether they conflict or not, it's changing.
So in other words, 2193 on the salmon sheet requires consent from a private attorney. And this addition to 2195 on the purple sheet would require consent if a court were to appoint somebody who was on the roster. Is that basically what they're doing?
That's how I interpret it. And if that's not what's meant, we can fix it.
Okay.
Yes, if your name is on the roster, you have consented to be assigned. So like that's taken care of. It takes care of itself. Can I have a minute to go back to history just briefly?
Yes.
So the genesis of these bills were the reports that came out, so the annual reports. So I think these bills were not drafted or conceived as coming to you as a package, even though it makes sense that we're here because they all came about at the same time. So 2195 was not intended to go with the alternative process. 2195 is to clarify what process we think the lawful process is or should be moving forward in the absence of the authority granted in 1807 that expired, that we're considering, that you're considering continuing in the salmon colored document. So that's kind of part of the conflict here. The 2195 is really, the intent is to get very clear clarification from legislative intent in the statutes about what process, the provision of indigent legal services, which is a specific and defining, it's in our enabling statute, actually, it's a definition in our enabling statute, how those get provided. So who's in charge of the attorneys, the appointments, and the funding that goes with that. And that's really just to clarify, because there's been different disagreements. There's been multiple court orders that have suggested all sorts of things about how attorneys can be put on cases and not put on cases, whether they have to be paid at all, things like that, which is concerning because we just want to make sure that as PDS, we believe our purpose, our entire purpose actually, was to train, recruit, set up attorneys, oversee them, and pay them for the provision of indigent legal services. And we think that's the only appropriate process. We don't particularly like the alternative process. We're trying to be good partners. We will not say no to help trying to get that accounts list down. That's a constitutional crisis, and we're doing everything we can, continue to do everything we can to get that list eliminated. That's our very first priority this year. This is what we think 1807 is intended to do. And so we've suggested some language. Again, we can live with this. Do we like it? No, we want our regular process. We don't like the fact that there's a crisis right now. But you know, we would like to be in normal times. 2195 is really intended to encapsulate what normal times is. We see these provisions of small amounts of like extra authority or extra irregular process, if you will, as an emergency measure to deal with our current constitutional crisis. We welcome that. You know, I'm going to be back before a court at some point in the next 12 months dealing with that constitutional crisis. And so we're not going to say no to anything that's going to help us with that. We can't. We just can't. We have to do everything we can within our power. And so that's really, I don't conceive of them as really intermingled provisions. Trying to work them together, I think it makes more sense to have 2195 be effective the date that the other statutes repealed. I think that makes it clear. But I think they can coexist because you're right. You can say this has to be followed because this is the regular process. So they could live together. I hadn't thought of it that way, but you are absolutely correct. They could live together because this irregular process really is somebody who's not in our system. It's somebody outside the system. And so that this authority grants to that person. I hope that was clear, not less clear.
Representative Lee?
So I'm just trying to glean PDS's preference. Would PDS prefer us to allow 1807 to sunset and walk off into the sunset, or would you prefer the salmon sheet?
We would prefer 1807 to sunset. That being said, we have heard informally, we have tried to work together with judicial branches that they feel that this is an important tool that they have. And if they feel strongly that's an important tool that they need to have, we can live with this statute until some date in the future when it expires. Do I like to have an irregular process that's outside of our purview? That's, you know, not well communicated? No. But demonstrably in the last 12 months the months that it was alive, you know, it was little used in terms of appropriately. We think a lot of them should have been through the regular process, but we'll pay people who are regularly appointed on cases. Not going to get caught up on what statute they cite in the appointment paperwork. We want people on the cases. We hear what they said. We've heard from members of this committee. We respect trying to make sure that people have the tools they need to deal with this constitutional crisis. And if that means we need to live with something that we don't love, that's fine. Then we'll do that. We don't love where we are right now. We want to be in a regular process because things are working the way they should.
I asked you a question about the sequencing of these two pieces of legislation. I understand the proposal for making 2195 effective as of the expiration of 2193. But when I hear you talk about normal times, which I'm hoping we're going to get to very soon, it seems to me like if 2195 is going to be the normal process, wouldn't we want that to be on the books now so that whenever the normal circumstances exist, the normal process is followed?
Yes, I think I had been thinking about it in a very like one and then the other two-step process. And it wasn't until I think I heard Janet's really clear explanation about why they can coexist that I really understood they actually can coexist. I think in my head, it was like one step, two step. And I think I don't think it has to be that way, but I was not conceiving of that until I heard her explanation.
And it wasn't true the way they were originally drafted. It's only with your amendment.
Other questions, committee members? Not seeing any. Janet?
I don't know if this is appropriate, but I did want to point out one issue because we kind of like went around weirdly in the bill analysis. But to reiterate one issue that I haven't vocally stated, the court's main objections to 2195 wasn't about consent or anything like that, but they wanted that provision to talk about when PDS is responsible to pay as opposed to when the court has authority to appoint. I know that subsection 2 of 1802A, which takes effect 90 days later, talks about the court's authority to appoint. So you may be fine with similar language, but you could, for a policy reason, distinguish between when the court can appoint an employee of PDS versus when the court can appoint another private attorney. That's really up to you, but I just want you to know that that issue's out there and I didn't vocalize it because we kind of start jumping around. Probably because of these really cool, pretty paper and colors. Maybe.
I'm sorry, could you please just restate that
Certainly.
issue?
So if we ignore the other bill for a second and we just look at what the normal circumstances proposal is, it's to talk about the way it's drafted in 2195 in both original and the amended version is to say that the court can't appoint these counsel unless the qualifications meet PDS qualifications, i.e. they're on the roster. And now, as it's proposed in purple, and the person consents. The judicial branch in its testimony on LD 2195 referred to its inherent authority to appoint folks. And they noted that when you passed LD 1101 last session, instead of talking about when can the court appoint folks, you talked about when is PDS responsible to pay somebody appointed by the court. So you could restructure the language that way. I do want to point out, however, in subsection 2, which you see, that's going to be law 90 days from now, you do in fact limit when a court can appoint folks. I'm not suggesting any input on whether that violates separation of powers. I am not taking a position on that, but you do in fact have that language there. So whether you think it's appropriate, both in the circumstances of when a court is appointing an employee of PDS and in new subsection 3, if you go for it, for the circumstance of when the court appoints somebody on the roster, that's up to you, whether you think those are different. And so you can just talk about when PDS has to pay as opposed to when the court can appoint. That's really up to you. But I did want to point out that that was an issue raised that I just hadn't mentioned orally.
ED,
I don't know if I made it more confusing, sorry.
Well, I think what you're saying is that as currently written, 2195 is basically prohibiting the court from appointing, but the way we structured 1101 was relieving PDS from payment.
Exactly.
And so what is the mechanism going to be? Okay.
Exactly.
And could you please comment on that, ED Turpinian?
Yes, I know I've had preliminary discussions a while back with the court about this. I'm going to let them state their preference. I don't have one. I think I will say that PDS employees as executive branch employees should not be directly appointed to a case. There is a separation of powers issue there that I have very strong feelings about. For assigned counsel, that issue is not the same. It's very different. That being said, I think where our lane, staying in the lane of PDS, where we have an interest in is making sure that we're very clear on the funds that were appropriated for our agency are expended in line with our enabling statute, within our authority. And so I think that I am perfectly happy to have it rewritten in terms of what we're responsible for paying and to sidestep the issue of apparent authority. I'm not ready to speak on that today. That's an extraordinarily complicated and somewhat controversial topic that I don't think is necessary to have to effectuate what we want. We're not interested in trying to curtail the court's authority. We're really just interested in making sure that the money that we're appropriated is spent in line with our granted authority.
Okay, thank you. Any questions, committee members, before we hear from the judicial branch representative Sinclair?
Thank you, Madam Chair. I'm going to ask the same question to the branch, but would PDS have any discomfort with our making it clear, not just absolving the commission of obligation to pay if there are appointments in contravention of paragraphs 2 and 3, rather than absolving PDS, we make it clear that the branch would be responsible for paying those attorneys that were appointed in contravention of either of those two paragraphs.
I don't have an opinion on that. I think that it's a policy decision that doesn't affect PDS's appropriation. And so I would leave it to the people who are making the statute. But I don't have an objection.
Do you have a follow-up?
I just want to make sure that those folks, if they are so appointed, are still going to get paid and not by the commission.
Yeah, this was really born out of an attempt to make sure that appointed folks have some protection. There were some court orders earlier this year that I know you're aware of that caused some anxiety amongst members of the bar. And I think as an agency that recruits, trains, and supervises them, we have an obligation to make sure that we do everything we can to make sure that they're supported in their work.
Thank you both. Representative Lee?
Now that we're on the subject of money, my question relates to, at the end of Janet's memo, it reminds us about this allocation that happened as part of 1101 of an amount of money that was appropriated for the purpose of those 1807 appointees. And in PDS, is that money sort of segregated just for 1807 expenditures, or is it for all assigned counsel, including?
I would have to go back to our accounting department and look. I don't know the answer to that question. I will get you an answer to that question. I came in late in terms of when those decisions were made, and so I didn't participate in that sort of fact. We tend to have we have two pots of money that we think about. We have our personnel line, which is dedicated, and we have our all other line. But that all other lines, there's appropriations for specific things in there. So it very well could be one of those lines. I just don't have the minutia of those lines.
Any other questions? Thank you.
Thank you very much.
Julie Finn, could you please rejoin us? Hello, welcome back. Would you like a question, or were you just able to share your reflections on our discussion of how paragraph 3 in 2195 should be structured?
Julie Finn for the Maine Judicial Branch. What I heard, I think, was Janet offering to restructure subparagraph 3 and Director Tarpinian agreeing that that would be acceptable to them. I would like to see language on that, but I would third that might be a good way to proceed on this.
Just to clarify, I didn't say it was a good way to proceed, just if possible.
A way to proceed.
Sorry.
And so you can't offer an opinion on whether it would be a good way to proceed unless and until you see the language, or?
Well, I very much appreciate that Janet brought up the court's issue with the inherent power and some of that language. And so I would prefer, and I was thinking it before Janet said it, that this be worded differently and put it with more of the compensation piece than the court's ability to appoint. And I recognize that subsection 2 is already is in the law and will become effective in July presumably. But I would certainly prefer different drafting there and
Mhm.
yeah, I think that's it.
Okay.
Yeah.
Yeah, and I agree with you that we're not trying to resolve that issue of the court's inherent authority. We're trying to leave that out of the equation and just address the payment structure.
Right. I think the better path is to avoid that issue for all of
Yes.
us, but
Yep.
thank you.
Questions, committee members? Representative Sinclair, did you want to raise your issue?
So I don't know, Julie, if you heard the question that I put to Director Tarpinian with respect to the issue of either A, just saying the commission doesn't have to pay folks that were appointed by the court in contravention of paragraphs 2 and 3, and instead rather saying that the court, if it chooses to contravene paragraphs 2 and 3, would be responsible itself for those payments. Do you have a position on that? And if so, is it warmly embracing that suggestion?
It is not, and I will say that, and this kind of opens like a whole other category of issues. I mean, the whole reason that what was originally the main commission on indigent, I can't remember the words anymore, indigent, whatever, MCILS, was created is because of the awkwardness of having the court be paying counsel who are appearing before them. And that is absolutely something that I think has worked extremely well, having a separate executive level agency to do that. So the court does not wish to get back into the business of paying attorneys. And I think that's in even contravention of our mission to some extent. So I cannot say that that is something that we could accept. But you know, if I don't, you know, not having seen the language, yeah, I can't say that at this juncture.
Any other questions, committee members? Representative Kuhn?
Yeah, just a process question for the committee. I mean, do we feel like because these are addressing two different categories of attorneys that we could move forward with 2193 and hope that a similar process would evolve with respect to 2195? Or do people feel like these need to move together?
So are you suggesting that we vote on 2193 today and then have asked Janet to draft language for 2195 to bring it back to us? Janet?
I just want to point out, if you know that you want a specific language change, like, for example, the proposed change that the purple amendment be changed so that it's about when PDS has to pay and not when the court can appoint, you don't have to wait for language. You can direct me to draft that language. I can ask permission to share it with Julie and get her sign off before I bring it back to you. So I don't think you need to wait to vote for that reason unless you're not comfortable without seeing the language in advance. But I promise I will do what you say and draft it that way.
Thank you. And Julie, would you be comfortable with working with Janet on that language?
Yes, absolutely.
Okay, thank you.
I might also ask just out of parity to also be able to share it
Yes.
with PDS.
Thank you. Representative Sinclair?
I'd like to make sure that we have at least a brief caucus before we race to a vote. I just wanted to make
Okay.
that clear.
Yep. Any other comments, questions, information needs? Representative Crusoe?
So just to be clear, so we have it clear in our caucus as well.
Mhm.
So you're saying add the financial part to the purple?
I think the proposal is for the purple, revise it so that it just says, instead of when can the court appoint assigned counsel, it says when is PDS required to pay assigned counsel that have been appointed by a court. And then independently or together, up to you, these sort of agreed to machinations together in the Salmon Amendment with the in advance of change for the private attorneys who aren't on a roster already.
So we're not merging the two together. We're just
I think
doing
that's
it
up
separate.
to you, but it's a possibility maybe of keeping them separate.
Yeah, I think that's what Representative Kuhn was suggesting. And,
But the compensation is in this one.
So that is another important piece. I'm glad you raised it.
Okay.
So LD 2193, and I think that Representative Lee was getting to this a little bit as well. LD 2193 is extending 1101, which was this new obligation of PDS to pay attorneys that weren't already in their system when appointed by a court. That was accompanied last time by the appropriation allocations. This part, there were other things 1101 did, so I just took out the relevant part, which gave additional funding to PDS. I thought it was just to cover the cost in the bill, but I think Representative Lee raised a good question. It might have just been for any increased costs of assigned counsel. So in the testimony, both from PDS and from the judicial branch, I guess that wasn't the other bill, never mind. But it may, sorry, we have 3 bills today, for attorneys. So it may be when this goes through the fiscal note process that it's determined that additional types of similar funding need to be provided if PDS is going to take on this payment responsibility. That's not anything to do with 2195 though, because that's the regular process. That's, I mean, yes, there's a shortfall, but that's the regular funding process you already have. This is just the additional attorneys appointed process and they have to pay them.
Okay.
Senator Hagan?
Thank you. Before we head out, can you or somebody give me a bulleted 1, 2, 3 as to exactly what we're gonna do before we either table or vote them out?
Yeah, so I can reiterate the suggestion. Is that okay, Representative Kuhn, that Representative Kuhn made? So the first thing on the salmon sheet, the consideration would be an ought to pass with this amendment, but including 2 more additions that didn't come to light until after the salmon sheet was prepared. And that is when it says consents, it should say in advance in paragraphs C, both paragraph Cs. And that this would be only in effect for a year and a month. And then the purple sheet would be the sort of the status quo, like the normal functioning. And the motion would be to pass it as prepared on the purple sheet, knowing that it would essentially what it would say is that if the court appoints an assigned counsel and that counsel is someone the commission has determined is not eligible for appointment, then the commission doesn't have to pay. So that is what's under consideration. Should we have a brief caucus break, everyone? Oh, yes.
You had me until the last part. In 1802, number 2, it says the court may not directly assign.
So that's very confusing. I'm glad you raised it. So subsection 2 is just about PDS employees. We think of them all as public defenders, but the term employed counsel is like in child protection cases because a public defender is in a criminal or juvenile case and employed counsel is in a civil case. So like involuntary commitment, emancipation, those types of civil proceedings. Those are all PDS employees, and what you enacted and which will take effect 90 days after you adjourn is that the courts aren't going to directly appoint those PDS employees. This new subsection 3 is about assigned counsel. Those are, we think of them as private attorneys, but they're people on the roster.
But appointed outside of the roster system and maybe not eligible on the roster. for
So
that
the
case.
commission doesn't pay for those who are assigned.
The commission pays for those who are assigned now. This language would be clarifying that they have to as I interpret it, actually be on the roster, meet all the qualifications, or PDS isn't going to be required to pay. There isn't some, other than for potentially a short-term time, there isn't some other obligation of PDS to pay some other attorney appointed by a court who's not on a roster 3 years from now.
Or an employed by them.
Yes. Well, they just can't, they have to pay the people employed by them, but they
Right.
can't be, they can't be appointed by them.
Yeah, right.
I don't want to say they don't have to pay them.
Okay, is everybody ready for caucuses? Caucuses. Thank you, everyone. Let's check in with each other around 3:10, please. Welcome back, committee members. If you could please take your seats. So we are continuing our work session. We opened up a work session on 2193 and 2195. I opened up for committee discussion. My only suggestion is if a committee member wishes to make a motion, that you make it with regard to one of the two bills, and we vote them one at a time. Representative Sinclair.
Thank you, Madam Chair. With respect to LD 2195, I move ought to pass as amended, pardon me, with the amendments being the purple sheet, with the change that was discussed with respect to subparagraphs 2 and 3, switching it from the may not language to instead have the language regarding payment.
I believe you only mean subsection 3, right? To change the language.
Yes, thank you. I apologize. Thanks for catching that.
Is there a second? Second by Representative Sato. Any discussion, committee members? Is the committee ready for a vote? Here's that we are. Thank you, Clerk Panet.
You're very welcome. And just to double check, 2195.
It's 2195, and it's ought to pass as amended by Representative Sinclair, seconded by Representative Sato.
That's what I have. Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Representative Poirier. Representative Poirier is absent. Representative Henderson. Representative Henderson is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative. 4 members are absent, and that is the vote of the committee.
Thank you very much. And so that's unanimous of those present, with 4 members having until noon on Monday to register their votes. And so we'll close the work session on 2195. Representative Kuhn.
Thank you. With respect to 2193, I would move ought to pass as amended with the salmon sheet and the addition on page 2 in both paragraph C of the words in advance.
Thank you, Representative Kuhn. Is there a second? Second by Representative O'Halloran. Is there any committee discussion? Is the committee ready for a vote? It appears that we are. Clerk Panet, thank you.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Representative Poirier. Representative Poirier is absent. Representative Henderson. Representative Henderson is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative. 4 members are absent, and that is the vote of the committee.
Thank you very much. And so that also passes unanimously, of those present. And so we'll close the work session on 2193. And that leaves us with just one more bill to work this afternoon. And that is, we'll open up the work session on LD 2194, which is an act to clarify responsibility for compensation of court-appointed attorneys in certain proceedings. Thank you.
We are ready when you are, Janet.
So LD 2194, as Senator Carney said, is an act to clarify responsibility for compensation of court-appointed attorneys in certain proceedings. So the Maine Commission on Public Defense Services evaluates the qualifications of and trains, supervises, and compensates attorneys appointed by state courts to provide a term of art, quote, indigent legal services. And that term is defined in statute. So the current definition of indigent legal services, which is in section 1802-4 of Title IV, which are the PDS statutes, that definition includes attorneys appointed to represent indigent individuals who have a constitutional or statutory right to counsel at state expense. That's a general sort of a overview of what it says currently. There's a few minor little exceptions, but that's generally what it says. The bill amends the definition of indigent legal services to clarify that PDS also has the responsibility to evaluate the qualifications of, train, supervise, and compensate attorneys that the state court appoints in the following additional circumstances: to represent a juvenile who petitions for emancipation and who requests appointment of counsel. Number 2, to represent a child who is the subject of a child protection proceeding. Number 3, to represent an indigent person who's the subject of a proceeding under the yellow flag or red flag law. 4, to represent a person who's the subject of an application for involuntary commitment or involuntary treatment. These are mental health commitments and treatments. 5, to represent a non-party witness in a criminal or civil proceeding when the United States Constitution requires that the state provide representation to that witness, which we were calling for shorthand Fifth Amendment counsel. And then 6, to represent an indigent parent or guardian in a child protection proceeding, which we do know they generally do, but even when the attorney provides services to the parent or guardian related to the entry of an order of parental rights and responsibilities, when that order is being used to facilitate disposing of the child protection proceeding. So that's the overview summary, but in the next part, I'll give you hopefully a little helpful information and not too much annoying information. So for the first category, to represent a juvenile who petitions for emancipation and requests appointment of counsel, all the actual statutes cited are in your handout from the public hearing on Buff. But currently under Title 15, which includes the Maine Juvenile Code, Section 3506A, a juvenile may request counsel. And then if they request counsel, the district court appoints counsel. And use of this word may is possibly lending confusion to whether this statute creates a right to counsel within the meaning of the current definition of indigent legal services. I'm not suggesting anyone is confused, but I'm just saying that's a possibility out there. PDS does already pay for these attorneys appointed to represent juveniles in emancipation proceedings, but making it clear here would help clarify that that is in fact their responsibility. The second category is representing a child who's the subject of a child protection proceeding. So usually the child's interests in a child protection proceeding are represented by a guardian ad litem, and they represent the child, what they believe are the child's best interests. But there are some cases where the guardian or the child themselves requests that the court appoint separate legal counsel for the child in those cases. And just as a very shorthand reason why, the guardian ad litem makes an independent determination of what they believe is the child's best interest. The child may have a different opinion of what's in their interests, and that might be a situation where the child has their own attorney to advocate for that different position. Under current law, the district court shall pay the reasonable costs of the child's counsel. So currently, the judicial branch does pay for these attorneys. However, and these are rare appointments, is my understanding. However, PDS used to pay for these counsel until August of last year, at which time it ceased paying these counsel as a cost containment measure because they were not required by law to pay them. The district court is set forth in statute as paying them. I do want to point out that the way that the bill writes this provision, it sort of bleeds over onto the top of page 2 of the bill. So if there's a child protection proceeding, counsel is appointed for the child independently of the parents and the guardian ad litem, then the child must be considered indigent and the appointment must be a public expense. There isn't a separate indigency determination for that child. So the next circumstance are the yellow flag law proceedings. So the bill would provide that PDS pays and qualifies and supervises attorneys appointed to represent someone who is the subject of a yellow flag proceeding. Under current law, it provides that at a final hearing following issuance of a temporary yellow flag weapons restriction order, the restricted person has the right to be represented by counsel and the court may appoint counsel for an indigent party. Use of that word may means that is discretionary. I am not suggesting that it doesn't always happen, but it is in fact in statute as may. And the current law defining indigent legal services is about when you have a right or when the state is required to provide representation. So that adds a little confusion. So previously, PDS did pay these attorneys. And then again, as you know about the shortfall and there were cost containment measures because this language is may, it's discretionary. It wasn't statutorily required that PDS pay. They stopped paying and the judicial branch has been paying since the beginning of September last year. The next category of folks is to represent an indigent person who's the subject of the new red flag extreme risk protection order proceedings. So that red flag law took effect this week. So I don't believe anybody's been paying yet because it's literally brand new as far as being effective. But under that initiated bill, at a final hearing for a red flag law weapons restriction order, similarly to the yellow flag law, it says the respondent has the right to be represented by counsel and the court may in its discretion appoint counsel for an indigent party. And then it says the state is responsible, but use of this word may makes it discretionary, makes it a little bit unclear. Does that qualify as indigent legal services under the current definition or not? What the bill does is it would clarify that it's PDS who's going to pay. And I keep talking about paying, but I think it's really important to remember that it's, if you define it as indigent legal services, compensation is the piece we most often talk about because of the budget, but it also means that they decide the qualifications and do the training and oversight and everything else. So then the next category is to represent a person who's the subject of an application for mental health involuntary commitment or involuntary treatment. So under current law, after a person's been temporarily hospitalized through the blue paper process, the court must conduct a hearing at which the person has the opportunity to be represented by counsel. And if neither the person nor others provide counsel, the court shall appoint counsel for the person. So that does sound like a right, but current law, which is in effect until 90 days after the session, does further provide that the district court is responsible for any expenses incurred under this section. You passed out of this committee LD 1796 last session. It's the same bill we talked about earlier. That will take effect 90 days after this. It does amend that provision to clarify that the district court is not responsible for the fees of appointed counsel. If you enact this version of this bill, that will even tidy it up even more, put a little more suspenders to the belts and say, and in fact, it's PDS who pays because these are indigent legal services. The fifth category is to represent a non-party witness in a criminal or civil proceeding. These are the Fifth Amendment counsel. So you might be called as a witness, and you might be asked questions that would require you, if you are going to answer them, to incriminate yourself. And under the Fifth Amendment to the U.S. Constitution, you have a right to be represented by an attorney when that sort of situation occurs. That's why you get Miranda warnings when you're arrested, for example. So Maine statutes don't currently talk about appointment of an attorney in these situations. But PDS has explained that counsel may be required under the Constitution, and that currently, in those rare circumstances, it is paying for those counsel, is my understanding. If I got that wrong, I hope they correct the record. So that's the proposal here, is to make that very clear. And then the last category are payments for attorneys who we already know are appointed, and they are PDS attorneys. And these are attorneys appointed to represent a parent or guardian in a child protection proceeding. But there is this one little unique twist to the child protection proceeding statutes, which says that maybe all you need to alleviate jeopardy is to enter a parental rights and responsibilities order that gives everybody clear guidelines of contact and supervision and all of that for the child. And if that happens, under the statute, they open a separate family matters case to put that parental rights and responsibility order in. And that's for confidentiality reasons. So all the child protection stuff that's confidential stays in the child protection case. The public parental rights case doesn't refer to all that. So it's a separate docket number. And there's a request here for clarity that even though that's a separate docket number, technically they might be representing somebody in a family matters proceeding. They still are the attorney appointed and supervised by PDS for the child protection case. So for purposes of that entry of the order, they would like clarity that it's PDS who pays those additional services that those attorneys are providing. So that's the way the bill is structured. And then at the amendment, there were some suggestions made.
Janet,
Well,
can we just pause for one second
sure.
before we get there? Is there any questions, committee members, on the material Janet's already covered? Wow, you must have really crushed it. We're all with you.
Okay, or you're tired and tuning me out. So the judicial branch and PDS proposed technical changes about the location of some of this language. So I think it's easier to understand this if you look at the bill itself. So the bill proposes on page 1 to create this new paragraph C1 in the definition of indigent legal services, which is talking about the yellow flag and red flag law and the involuntary commitments. And generally speaking, these are representations to indigent parties. And that's what paragraphs A and B of the definition are about. That already exist in current law, whereas paragraph C in current law is talking about juvenile defendants who we presume to be indigent, so they may or may not really be. So the suggestion is, instead of making it C1, make it B1. So sort of like you start with the indigent folks and move on down the list. So that was one suggestion. Another suggestion that both the branch and PDS made was here in paragraph E, where I kind of smushed in the Fifth Amendment counsel. Maybe make that its own paragraph and don't try and smush it in there. Don't try and be too clever, Janet. That's what that suggestion is. There also are further suggestions beyond just where that Fifth Amendment counsel language is located to the scope of it. So PDS proposed limiting the circumstances in which it was going to be obligated to pay Fifth Amendment counsel. And remember, if it's the definition of indigent legal services, that coincides with the obligation to pay and supervise and train, etc. So they suggested limiting it only to situations where that non-party witness who needs the Fifth Amendment counsel is indigent, and if they're a witness in a court proceeding where other people in that proceeding are already entitled to counsel for that's indigent legal services. So this wouldn't be, there's a family matter proceeding between two pro se or not pro se parties, but who don't have a right to an attorney. They might have one, but they don't have a right to attorney at public expense. They're having a case and they call me as a witness and ask if I beat the child 3 weeks ago and maybe I might have to incriminate myself. I wouldn't have this right to PDS paying for my attorney. I have a right to hire an attorney in that case. It's my understanding that the idea is it's only if it's like a criminal case where there might already be PDS involvement. It's sort of to narrow down the whole scope of every case that could ever possibly exist where a non-party witness is called and might be asked to incriminate themselves. So that's a request that they made. And then also, I wasn't sure, so I guessed when drafting this committee bill that those non-party witnesses who have Fifth Amendment counsel might file appeals to the US Supreme Court for adverse decisions, but really they're not parties to the case, so that doesn't make sense. So they said you don't need to include them in paragraph D, so that's the other suggestion. This is where I got confused last time. So this is where funding is being requested. So as you know, there's currently a shortfall and some.
Senator Carney?
I just,
Pardon me,
sorry to
Tammy.
interrupt you, but, just jumping back to paragraph D, is the suggestion that all
Wait.
those references to non-party witness be stricken?
Yes, the non-party witness references and to paragraph E, that's not where we're gonna leave Fifth Amendment counsel, but that's where it is now. So we don't need to add.
I
Okay,
think we do have a separate sheet of paper in our folders,
Yes,
That
I'm kind
addresses
of
this?
summarizing
Yep.
what they said. Yeah.
but that lays out the language if anyone would like to see it.
I, of course, like to draft things differently, so. I'm gonna skip the funding for a second because I think that's an important piece, but I want to point out that if you look at what I talked about earlier with C1 moving up to B1, the justification for that was that A and B talk about when you have a right to counsel and the state is required to pay by constitution or federal or state law if you're indigent for your counsel. Paragraph C of current law, not with the amendment, but with current law, is if you're a juvenile, we presume you're indigent and we pay for your counsel if you have counsel appointed. And the idea was move all these other things up in between them because they're all involved indigent folks, which leads me to two questions that are in the drafting issues identified by the analyst section. First of all, for emancipation proceedings, it's not clear to me, and I don't think it's clear in the bill because I wasn't sure what you wanted, whether you want emancipation proceedings, which are also under the main juvenile code, to be treated similarly to juvenile crime proceedings under the juvenile code, which is we're going to presume the juvenile's indigent if they ask for an attorney and PDS would pay for that attorney. Or do you only want PDS to pay if the juvenile is in fact indigent? Which I just want to say as an aside is an odd question to be asking in an emancipation proceeding because that's kind of part of what emancipation is all about, is having your own financial resources. But that's just an editorial comment. So that's the question for emancipation, which is generated by this idea of the placement. Well, then do we want emancipation to be every juvenile who needs the attorney there? And then the next question is about involuntary commitment and involuntary treatment. So if we look at C1 in the bill, 1 and 2 are the red flag and yellow flag law. Those specifically talk about the state paying and court appointing an attorney for an indigent respondent. So that's written here. The court appoints attorneys in an involuntary commitment or involuntary treatment proceeding if neither the patient themselves nor somebody else provided them with counsel. It's not dependent on whether they're indigent the way the statute is written. So the question is, do you want PDS to only be responsible for paying that counsel if that patient is indigent, or in all cases, similar question to the emancipation question? So those are sort of technical about how it's drafted. All of those questions are separate from the funding issue, which I want to make sure we separate out.
Okay, so any questions, committee members on those two items? Yes, Representative Sinclair.
I'm going to apologize in advance, Janet, because I swear I did throw my hand up quickly when you were on the subject that I'm going to ask us to rewind to. But I wasn't seeing, and then I put my hand down because you were still going and I wanted to try to catch up.
So sorry,
All
I
good.
was talking.
When we were talking about Fifth Amendment counsel, I understood at one point that you suggested that PDS had requested that they be on the hook to pay for Fifth Amendment counsel only in those instances where parties to the action had counsel. And if I misheard that, I apologize, but if I didn't mishear it, I have questions.
So that's how I understood the testimony to be, but I think the question is better directed at PDS because in case I've misunderstood it, let's just maybe ask them exactly what they meant.
I can hold it until we bring Frail out. Thank you.
Right. I just would hate to mischaracterize it.
Okay, I think we're good. Keep
Okay, so
going.
then the last issue about, other than where you put things and whether people have to be indigent or not, and the scope of the Fifth Amendment Council, right? Those are all issues on the table. The last issue is, as you know, PDS is currently experiencing a shortfall. Part of the reason that PDS is not currently paying some of the attorneys in this list is because by statute, they don't technically have to. So they had to stop as a cost containment measure. They explained in their annual report. So both PDS and then the judicial branch agreed that you probably need to add funding. Now that would happen through the fiscal note process, but you probably need to add funding if PDS is going to take on these additional payment responsibilities because they don't have enough now for the responsibilities they have. So it was suggested as a proposed amendment, but that really is something that happens through the fiscal note process. We can sort of suggest to OFPR, we think funding is going to be needed here. Please ask how much, but I don't have control over that fiscal note process, if that makes sense. And then the last proposal was, if you don't mind, I recall Senator Carney, you suggesting maybe this could be an emergency preamble since there was sort of a influx change of who paid and maybe change that back quickly.
Thank you. Are there any questions for Janet? Yes, Representative Lee.
You have no reason to know the answer to this question, so, but if you do, great. Do you know, in the governor's budget, there's a substantial amount of money for the red flag law. Is any of that dedicated to PDS?
So I don't know. All I know is the portions that are in your budget binder that Eli put together. And that doesn't include red flag stuff. That doesn't mean there isn't red flag stuff somewhere else that wasn't allocated to us. I don't remember it, but I could be wrong. Maybe it's one of the PDS initiatives that I just glossed over really quickly.
All right, any other questions for Janet? Would any committee members like to hear from Freyla Tarpinian? Yes, could you join us, please?
Afternoon, Freyla Tarpinian, Executive Director of the Public Commission on Public Defense Services.
Welcome back.
Don't know who I am.
Are there any questions? Representative Lee.
My last question about red flag, do you know if there's any money in the governor's budget dedicated to PDS?
I do not believe so. I will double check that. I did not even think about that, to be honest with you. When I went through, I did go through the budget in preparation for tomorrow's hearing, actually. It was not something that we were made aware of either by our budget analysts or through my own. I did not read the entire budget. I can confess that. But a search of Commission on Public Services I did do throughout the documents and that did not. So I don't believe if it was included, it was earmarked in any way that you could discern that.
Representative Sinclair.
Director, did you hear my question to Janet immediately prior to Representative Lee's question? My question was dealing with Fifth Amendment Council and whether PDS was in fact looking to limit responsibility for payment of Fifth Amendment Council to those cases in which one or more of the parties in that same matter had counsel.
Not exactly, but close. The scope we suggested was limited to case types that are eligible for court appointment. So the list of cases which this would enlarge, if that case type had a Fifth Amendment counsel situation pop up, we would become involved. Fifth Amendment is not common because trials are not common and it only comes up at trial. I'm very familiar with it in the criminal realm based on the kind of case I prosecuted. So I've dealt with Fifth Amendment, but in my 10-year career, I think I've experienced it 4 or 5 times. So it's not frequent. What I'm concerned about and why I suggested the limitation is because I could imagine in my lawyer hypothetical brain a civil action where somebody is brought into court and there's a concern about Fifth Amendment us getting that call, which typically happens at whatever time that person's been subpoenaed in, to rush in and suddenly render legal advice competently in a civil action. I don't have anybody that I'm aware that could do that. I could make some guesses, but that would concern me. It would help to know the scope. We don't pay for those people currently. We do pay in the criminal realm. I could think of a case in a red flag or yellow flag law where this might pop up more frequently. I could think of it in the involuntary commitment, although typically it's not my experience that ever happens, but it could happen. It could happen in the PC realm. Same thing though. To my knowledge, we've never been asked to pay for a Fifth Amendment counsel in the PC realm. It could happen. We would be prepared to provide that. We could provide competent legal representation on a moment's notice in those areas. If we went and I've never done civil actions in terms of like large tort claims, insurance defense. There's a lot of case types I've never encountered. Nobody, to my knowledge, of my staff has encountered them either. We tend to be criminal defense attorneys with some family law experience. Pivoting to that type of law would concern me. We would need some expertise. And so the logical scope was, what's the scope of our mission now? What are the case types that we are responsible for? And again, it would be enlarged through this legislation, which is fine. We're comfortable with these case types. If we could bound it by that, it would be helpful. If I knew there were Fifth Amendment counsel in other cases, I could explore that. I'm not unwilling. I think PDS, from my perspective, will do whatever you want us to do. We'll get the expertise, we'll find the lawyers, we'll train them, we'll oversee them, and we'll pay them. I would be really worried to have this just wide open right now because I don't know what I would do if somebody said I have a large environmental tort claim action for multi-million dollars in Portland. Can you send somebody for Fifth Amendment? We don't know that. We don't know the answers to those questions necessarily. So I would be really worried about signing up for something we're not prepared to do. If that's something you want us to do, I can do it. It will take me some time, but I don't know how to do it right now.
Representative Sinclair.
The part I wanted to hone in on, I think comes down to our use of the phrase case type. I understand you to be saying case type in the sense of how they are docketed. However, a criminal matter in which the state is not looking for incarceration if the defendant is convicted is also a case type where there's no PDS involvement until and unless there's a need for Fifth Amendment counsel. And so I wanted to be clear that when we say case type, we don't just mean those situations where someone doesn't qualify for counsel, but rather in the more limited, the more court-specific type of docketing is what you mean by case type.
Yeah, so if it was an OAS with only a fine, that's not a case that PDS would normally be involved with. And absent very specific findings by a court, we don't usually get involved. It's a standard $250 fine. If for that reason there's a Fifth Amendment counsel, we absolutely could become involved because the case type, the criminal law, we can do that. It's really having to do with subject matter expertise that we don't have.
Other questions, committee members? All right, thank you.
Thanks.
Does anyone have questions for Julie Finn? Okay, I'm not seeing any. Oh, did you have a question?
She was so excited about it.
Yeah. Sorry, Julie, false alarm. If you could join us. Senator Carney has a question.
Julie Finn, Maine Judicial Branch.
Thank you. Looking for a little more information about the emancipation cases. Do you know whether or how frequently a juvenile requester is appointed a counsel in those emancipation cases?
I am sorry, but I do not. That is, I can make some inquiries if we go beyond today, but I don't have any information on that.
Okay. I just wanted to know a little bit more about that area. That's the only question I had.
Any other questions? All right, thank you. Senator Talbot Ross, would you like to introduce yourself?
Thank you, Madam Chair. Thank you for the indulgence. I know you've been working all afternoon. My name is Rachel Talbot Ross. I represent Senate District 28, which is on the peninsula of Portland. Thanks.
Thank you. Senator Carney?
I think Freya Tarpinian might have some comments on the emancipation.
Oh, good. If you could join us again. Hold on just a second. Let's get your mic.
Yeah, we do know about the emancipation numbers. So it's not every year that we have an appointed attorney. So it's a handful, 1 to 2, maybe every few years. So less than 5. There's, however, a national trend growing where there's a movement afoot to nationally to shift attorneys from a guardian ad litem model, which is what our state currently does, to a model where we have more attorneys appointed. So I anticipate in the future it may grow, but currently it's negligible.
Yeah, thank you. Any other questions? All right. Would committee members like to take a caucus break? Yeah. Okay, great. Let's take a break and we'll hopefully come back in about 5 or 10 minutes. All right. Committee members, welcome back. And we are continuing our work session on LD 2194. I'll recognize Senator Carney.
Thank you very much. I have one question for Janet, and then I'd like to make a motion. So Janet, you and I had a little conversation about the use of at the top of page 2 of the bill, the child must be considered indigent and appointment must be at public expense. And is it appropriate to include that same phrase in the section of the bill that relates to a juvenile who participates for petitions for emancipation? Is that the same language we would use?
Yes, if we look under the drafting issues identified by analysts emancipation, the way it's written in the juvenile code is if the juvenile requests an attorney, the juvenile must be considered indigent and counsel must be appointed. It could be that kind of similar language
Okay.
in the emancipation section.
Okay.
And I did check, and it is the understanding that all of those juveniles who request an attorney emancipation are getting the PDS attorney. There isn't an indigency form filled out at that point.
Okay. And then another question I had is, in that subparagraph 3, which is lines 20 to 22 on page 1 of the bill, that deals with the person who is the subject of an involuntary commitment proceeding. Does it make sense to say that they will be considered indigent just for consistency with the other aspects of the bill? Or is it better just to leave that as is, since we're not?
I don't think it would be a change to say that, and whether that's a helpful addition, I think I would defer to PDS.
Okay. Thank you, Janet.
You want me to rephrase it?
Yes, please.
So for the involuntary commitment proceedings, you and I talked about in the break.
Yes.
That the way the statute is it's not dependent on indigency determination. That's sort of current law already, but would it be better to be explicit about that in the statute? Say you just deem them indigent.
Absolutely would be.
Okay, thank you. Thanks a lot.
Thank you. Yes, Senator Carney.
So I'd like to make a motion, which is an ought to pass as amended. And so it would include in what is currently paragraph C of the bill at page 1, line 11 to 13, to include the indigency language that's currently found in the juvenile code.
Are you saying in 11, 13? So I would actually put it in the emancipation section.
Oh, am I not in the emancipation section?
No, I mean, in the actual emancipation statute.
Oh, rather than in this statute.
Yes.
Okay, understood. That seems much clearer. Thank you.
Yes. So I think Senator Carney is referring to clarifying in the law who's going to be deemed indigent, doesn't have to fill out the paperwork. In any of those cases, I would put that deeming them as indigent in the underlying statute where the court appoints them, not in the definition of indigent legal services. So it would be similar to what's in section 2 of the bill, which is saying if you appoint an attorney for the child, it says right in the statute, which talks about appointing them, that you consider the child to be indigent. It would be something like that in each of the appointing statutes. Does that make sense?
Great.
Yep.
Thank you.
So in section 2 is actually kind of the underlying bill. So I mean, the underlying statute, so to speak.
Yeah.
And so you would put it there. Okay.
So you're saying the motion is clarify in the emancipation statute that you consider the juveniles indigent.
Yes. And also in the involuntary commitment.
Yep.
And then do the reorganization that Janet you had proposed for that section that's found at lines 14 through 22. And then for at lines 23 through 28, delete the references to non-party witness, as we discussed. And then separate out the Fifth Amendment representation, the non-party witness representation as a new paragraph F. And I think that's all the changes.
Thank you.
So that was my motion.
Great. Is there a second? Representative Sinclair. Okay. There are questions of Representative Caruso.
So, with that fifth party issue, is that taking into consideration the director's concern about a large action suit?
Yeah, I didn't think that totally through, so,
Rachel says nothing's being broadcast.
Oh, thank you. Audio or video?
Supposed to be monitored.
She says, she's asking if committee's back.
Okay, we'll just pause for a moment.
We can see the video.
All right, looks like we're good to go. I think you, Senator Carney, were responding to Representative Caruso's question about the large litigation.
yes, and I did want to clarify that I intended the motion to include the limitation for non-party witnesses that would be restricted to criminal defense cases.
Just criminal? And if the non-party is indigent? Those are
Yes,
separate questions.
yes, thank you.
Is that acceptable to you, Representative Sinclair? You have a question?
With respect to Senator Carney, because it is your motion, and you're due respect at all times anyway, I understood the director to be saying that the commission wouldn't want to be on the hook for Fifth Amendment counsel in case types that are not already within their purview, but more than just criminal. So more than just criminal would be just peachy with the commission. So criminal, PC cases. What are the other case types that?
Thank you.
I
for
wrote
that.
down criminal, involuntary commitment or treatment, child protection, and the red and yellow flag.
Thank you. You are correct. And so if we could do cases that are already within the purview of the public defense services.
And I just want to be clear, I think the best way to write that is to in fact list the case types, if that's all right with you. Okay.
Representative Caruso?
So, I guess I just want to be clear that, there is no constitutional requirement to provide, counsel for civil cases. Isn't that correct?
It depends on the type of civil case. So a child protection proceeding is technically a civil matter. But if you take the child, if you terminate the parent's rights, there, I believe, is due process right to counsel there. Also, an involuntary commitment that is technically a civil proceeding. I don't know if there's constitutional case on it. I imagine there is. But there's definitely at least the statutory right to counsel there. There may also be a constitutional one because your liberty, it's just like being locked up in jail. You're now being locked up in a hospital. So your liberty is being invaded. And those are civil cases.
Okay. So just to be clear, is it your interpretation that the cases that we are including here would be required by due process?
As far as I know, I would have to phone a friend about the red and yellow flag law, but that is a Second Amendment right, so I'd imagine that's similar.
Yes, I would think for that, we would have to. Yeah.
Thank you for that clarification. Right, are there any questions on the motion? Or any committee discussion? We did, it was Representative Sinclair. Okay, I think we are ready for the vote. Oh, yes, Senator.
I'm just a little lost. I had the Microsoft Word version, not the one with the PDF with the numbers. Could you walk through what you did just quickly? Yeah.
Janet, would you like to walk us through it? Thank you.
It's a good way of checking I wrote it down correctly. Okay, so it would be the bill as printed plus amending the statute involving appointing counsel for a juvenile who requests an emancipation proceeding, amend that statute to clarify we're going to deem all those juveniles to be indigent. The same change for an involuntary commitment and treatment proceeding. The statute currently sort of suggests that you consider them all indigent, but that would be made clear, so there's no question about it. The next thing is what is paragraph C1 of the definition of indigent legal services here would become paragraph B1, just move it up a little bit in the statute. The next thing is where in paragraph D, you talk about a non-party witness, maybe filing an appeal to the US Supreme Court, take that out because they don't do that. In paragraph E, where the non-party witness, that Fifth Amendment counsel is, we're gonna take it out of there, make it its own paragraph, likely paragraph F. E right now is where I stuck in the Fifth Amendment counsel, so all the underlined in E is Fifth Amendment counsel, but it will be moved in Senator Carney's motion to a new paragraph, paragraph F. And in moving that language, it will be clarified to say that this Fifth Amendment counsel is only available to a non-party witness who is both indigent and called as a witness in a criminal, involuntary commitment or treatment, child protection, or red or yellow flag proceeding, no other case type. I think that's all the things.
Yep. I guess before we vote, I'll just add, I'm really pleased that we were able to get this together. I think it's going to really streamline process, be efficient, alleviate confusion. I really think it's, it's technical for us, but it's going to be very helpful for the parties involved. And I wanted to just highlight at one point earlier in the discussion, we did talk about possibly putting in an emergency preamble to shorten the period of confusion or overlap. I just wanted to see, is there interest in doing that, or should we just proceed as we are? Senator Carney.
Just trying to think it through. If we had an emergency preamble, then when the new fiscal year starts for both the state and PDS, then it would be in effect for the new fiscal year, or maybe we make it in effect for the new fiscal year. I'm wondering if the PDS director could give us an opinion on that. I'm just aware that there will be some changes in processes and thinking what's easiest for you.
I think for the process point, it'll be very easy to pivot back into taking these cases. Our system for assignment is not complex. My biggest concern, not to beat the other thing in my head, is 2059, so that you could make us responsible for paying for these cases, but there's a probability, unless something changes right now, that they could go into a list of people who aren't getting paid on time. So my preference would be to wait until the start of the fiscal year, because then I know that there'll be an allotment of funds to pay them, notwithstanding whatever else may or may not be happening.
Thank you.
Thank you. So we will not add an emergency preamble at this time. We'll not add an emergency preamble at this time because it could just add complications instead of alleviate them. All right, Senator Carney.
Just before we vote, I want to do a round of thank yous. I know that the PDS and the judicial branch and specifically Fred Tarpinian and Julie Finn have worked really hard on tying up all of these inconsistencies and loose ends with regard to how payment is done. And your working together and with us was really crucial to us getting this all squared away. And I think it sets a really nice, clear foundation going forward. And just we're grateful for all the help you've lent us.
All right, and with that, I think we're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Coons.
Yes.
Representative Coons votes yes. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson. Representative O'Halloran.
Yes.
Representative O'Halloran votes yes. Senator Talbot Ross.
Yes.
Senator Talbot Ross votes yes. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Representative Poirier. Representative Poirier is absent. Representative Henderson. Representative Henderson is absent. Representative Sato. Representative Sato is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, 4 members are absent, and that is the vote of the committee.
All right, thank you. So that's unanimous of those present. And I think that's the end of our work for today. Representative Sinclair?
For the first time in my history on this committee, I move to adjourn, Madam Chair.
Thank you. And we have a second. And Janet, would you?
I just want to remind you all that the hearing on the supplemental budget, that's your portion, is tomorrow morning. We do have the binders in our office, Eli and I, if you want to come get yours, but if you do, you have to remember to bring it back.
All right, that's tomorrow. And then I think we were also considering convening the errors bill subcommittee briefly following the budget hearing. Maybe if it's possible for you to remind us who volunteered for that committee.
I gave that list to our secretary to put the labels on the binders.
Okay.
I can email you all. How's
Okay,
that?
that would be great. And this would not be, I don't anticipate that would be a long meeting. It's to pass out the binders and go through a few examples so that everybody understands how the binders work
Yeah.
and can
So
take it
just
home.
come up here if you're on the list that I email out. And Eli and I will give you the binder, go through it, and you'll assign yourself homework of what portions to look at.
Okay. And then I just wanted to clarify one other thing. I think at some point we talked about meeting on Monday, and I just want to make sure there's no Judiciary Committee on Monday. And I think that's all of our announcements until tomorrow. Okay, all in favor of adjourning? All right, thank you, everyone.